Welcome to Real Talk, Indiana's premier talk show on real estate investing, where we talk each week about investing your money right here in Central Indiana. The tips, tricks, do's, and don'ts, brought to you by CIREIA, Central Indiana's oldest and largest real estate investing association. Hello there, my name is Vicki Perry, and I'm the Executive Director of CIREIA. We have over 600 members, all active in or learning how to be active in real estate here in the Indiana market. This radio show is available on FM 95.9, AM 950, podcast on YouTube, and www.cireia.org. Join us each week as we talk about how you can make your money more active with better returns and help the community that you live in with real estate done the right way. Now, on with the show.
Hello, my name is Ron Watson, and I'm the board president for CIREIA, Central Indiana Real Estate Investors Association. Welcome to CIREIA's weekly show where we talk about investing in real estate the right way, its ups, downs, and financial rewards. We're the largest and oldest nonprofit real estate investment group in the state, and our goal is to help you understand what the opportunities are for you, whether you have a lot of time to invest, minimal time, lots of funds, or minimal funds. And last week we talked about crowdfunding and passive investing with Matt Crawford, owner of Indianapolis Homes Realty. If you missed that episode, you can listen to it on the CIREIA YouTube channel or tune into it on our website, www.cireia.org, on the calendar of events. Joining us again today is one of the most successful investors in Central Indiana, Brett Snodgrass, broker, investor, wholesaler with Simple Wholesaling. Brett and his team did 354 deals last year and runs one of our most successful meetups. Welcome, Brett.
Thanks, Ron. Pleasure to be here.
Also joining us is Janet Hocker, licensed attorney in Indiana and Pennsylvania, owner of Hocker and Associates Law Firm, local expert for real estate investors, and an investor herself. And welcome, Janet.
Thank you. Happy to be here.
So, Janet, let's just start with a little bit of background about you and what made you decide to specialize in real estate law.
Okay. Well, right out of law school, I was given an opportunity to take ownership in a title insurance agency, which you don't have to be a lawyer to do, but I did take that ownership at that time, and that was in 1993. And title insurance is one of the tools that is used in real estate transactions, both residential and commercial. They're the vendor that provides the due diligence for the background of the title and making sure that sellers are selling what they say they're selling and buyers are getting what they believe that they are. It was just a natural progression within that agency to grow in the area of real estate law. And it's just continued to be a passion of mine that I really enjoy. I enjoy the people. I enjoy the transactional nature. Occasionally there's some litigation. But that's where I got started and continue to work in that field today.
Awesome. Well, thank you so much, Janet. I've worked with your company many times, Hocker and Associates, and it's always been a pleasure. And I remember I was looking for an attorney here in Indianapolis, and a good friend of mine out of California said, you really need to meet Janet Hocker, and she's the most knowledgeable real estate attorney that I know. So that's when we got connected, and I'm so thankful for that. But today's topic of the show is really going to hone in on seller financing, and a lot of our CIREIA members and your firm have closed many transactions, including a lot of my own, using seller financing. But those in our audience that do not know what seller financing is, can you dive into that and explain exactly what seller financing means?
Yes. So in a nutshell, I typically say that seller financing means that you, as the seller of the property, you're acting as the bank. There's many different ways that seller financing can work in a transaction. Obviously, you own the interest in the property that you're going to sell. And for whatever reason, the buyer is unable to pay you in full at the time. Or you may even want to just offer that straight out of the gates, it's a seller financing, you want to hold it. There are a few different tools to do that. One is a land contract, also called an installment contract. It's also been called contract for deed. all of those terms, it's the same thing. It's a contract agreement between the two parties that say, I'm going to buy the real estate for this amount of money and I'm going to pay it to you over time. All the other terms are negotiable. How much is the down payment? How much is the interest? What is the monthly payment? What's the term? All of those things are negotiable. The most traditional way for financing a transaction, which can also be seller financing, is the deed, note, and mortgage. In that case, the seller transfers the deed to the property. The buyer gives a personal promissory note, which is their promise to repay the purchase price. And then the mortgage is the security that the seller gets that creates a lien on the property until the note is paid in full. Again, the terms of the transactions are negotiated. How much is the seller going to require in interest? How the payments are going to be made? And typically you work those things out and move on to closing.
Can you talk a little bit about what some of the reasons would be for somebody to want to offer seller financing and maybe some of the advantages and disadvantages?
Sure. From a seller standpoint, if you're able to hold the property and not require immediate funds, you can get a pretty decent rate of return for your investment. There are some closing costs that you maybe wouldn't have to have if a buyer is going through traditional financing with a lender. So you could have a cheaper transaction cost. You may want to be able to sell the house as is. Therefore, the appraisal wouldn't be as significant because the buyer would be willing to take the house as is, where if they have a lender, they're going to have a specified appraisal amount and maybe some conditions to close. Or you have a buyer that you really want to sell to, but they just can't get traditional financing for a variety of reasons.
Yeah, that's awesome. I definitely have used seller financing, and I wanted to really dive into the returns. I know on our last episode we talked with an equity fund with Matt Crawford and Mike, and we talked about their returns. But what are some of the typical returns that if I were to sell my house right now, what would an average return be that I could ask for if I'm going to seller finance it? What are you seeing coming into your office?
And it really depends on if the buyer is able to put a healthy down payment down. You might get a little bit lower interest rate. I really am not seeing any land contracts or seller financing less than 8%. And generally I'm going to see it between like 9 and 12%. If it's a very high risk with a low down payment, you can have it as high as 15%.
Is there any laws of how high you can go that you can't say, hey, I'm going to charge somebody 50%?
Well, there is a difference between if you're selling to an actual owner occupant, meaning that's going to be their primary resident, or to an investor. And in Indiana, really the investor, it's set by the market. There's not a limit on it in that regard. And there are some usury laws with regard to owner occupants, and I believe, which those rates do change, but I don't believe that you can go above 20% with regard to a land contract sale for their primary residence.
Awesome.
So what did you have in mind, Brett? Did you want to?
Well, I was just wondering. I was trying to get a 50% return.
There you go. So some of the deals that you're seeing, do people come to you with kind of all this figured out, or they come into you and saying, hey, I don't know how to I got somebody that wants to buy this property, but I don't really know what the best way to structure a deal is? I mean, are you seeing lots of different levels of expertise with these kind of deals?
For sure. People kind of have an idea of how they want to do it. They've maybe heard that they can do it. But, the bottom line is that if you have a willing buyer, then there's a way that we can put this deal together if there's a willing seller. Is it
limited to, what we would typically think of as an investment property? I know Brett does a lot of wholesaling houses, and they're not always the same price range, but there's a kind of a niche there. Do you see that with these types of deals? I mean, could they be, $400,000 residential houses or $50,000, everything in between, or what do you typically see?
I see everything in between. I will say that most of the transactions where there's seller financing is going to be where the buyer is unable to obtain conventional financing or through FHA or something like that. And so those are going to usually be first-time home buyers, and that market is generally between 50 to maybe high-end 200,000. But there's lots of you can do these transactions on very short notes, balloons, so that's really attractive to investors. So sometimes they'll do those, with a much higher dollar amount.
If I were a buyer wanting to buy a property that somebody was seller financing, is there an advantage for me in that scenario? We kind of looked at it from the seller side, but what about from the buyer side?
Well, again, if you can't obtain financing through the traditional means to pay that seller in full, it's an absolutely fantastic way for a buyer to build equity in a property quickly, and they're able to usually close very quickly, much quicker than traditional financing. When I say that, you can build credit, I always tell the buyers, keep very, very good records, because you don't typically have a seller finance transaction where their seller is going to be reporting payments to credit reporting agencies. But if that buyer wants to buy on a land contract with a 1-year balloon, knowing they're going to go to obtain financing and pay that off in a year, they're going to want to be able to show every month that they made their payments by their own independent records. And usually the sellers have really good records too. Well,
so after we have to take a little break here, but after we get back, I want to dig into a little bit more detail on how somebody can actually set up a deal, a seller financing type of deal. We also have the hot seat coming up, and I know Janet probably has a tip of the week for us, and we'll get to all of that information when we get back after this.
Real Talk, real estate investing the right way. Brought to you by Central Indiana's premier real estate investors association, CIREIA. Check out upcoming guests weekly on the calendar of events at www.cireia.org.
And welcome back to Real Talk. My name is Ron Watson, president of the board of directors of CIREIA. And today we're speaking with Janet Hocker, real estate attorney, owner of Hocker and Associates Law. Also joining me is Brett Snodgrass, local investor and coach. So Janet, we were talking a little bit about how owner financing works, and how do realtors feel about this? Or you find that sometimes they don't know much about it, or are they resistant if I want to bring a realtor in, or can you talk a little bit about that process?
I think that what I usually see is that realtors are reluctant, but probably because they're not fully educated in how it can benefit them within the real estate community. One thing that I think people are a little bit hesitant is to ask for a healthy down payment. When you, as I said, the seller's acting as the bank, and we all know that the banks always require pretty healthy down payments. If they can get them. And with that down payment, there's going to be money available at the time that the sale is closed, that the realtor would be able to obtain a commission. And if the realtor obtains their commission at closing, really that's just like any other transaction that they do. The other thing is having that realtor understand that you're going to have those buyers that cannot otherwise get into a home, and you being a little bit more flexible maybe with your commission is getting that in into a home, and that's just going to give you goodwill for, in your career going on down the line.
Yeah, that's definitely good advice, Janet. You talked about some of the advantages of seller financing in the first segment of the show, according to the buyer and the seller. The seller can get a decent interest rate. The buyer might not be able to afford a traditional loan, and he's able to buy a home using seller financing. But what are some of the disadvantages of seller financing? What are some of the pitfalls that you've seen when somebody uses this strategy?
So when I said that it's a seller finance transaction, obviously that puts it into a private relationship. as opposed to when you're dealing with a mortgage company, you have a big public lender, and really what happens personally to any one individual isn't going to be a driving factor in that relationship. Some disadvantages when you do seller financing would be that a party dies. It could be the seller dies. It could be that the buyer dies. And you have a transaction then that's going to be governed by the surviving people that are managing those two individual estates. So if that would happen, you would probably need to seek some legal counsel to get through that and make sure that the deal continues as the surviving parties expected. The other thing is there could be some legal ramifications if your documentation is not done correctly, your interest is not recorded as the buyer or even as the seller. When you again do traditional financing, you have someone else looking out for those types of things, and it's usually the bank. They want to make sure that they're as protected as possible. So if your due diligence isn't done correctly, again, you're probably going to need to engage the court system to help you untangle maybe some of the problems. And you do have parties that don't have as deep a pockets and the ability to remedy maybe defaults as you would in a typical transaction where you have a lender involved.
So I want to dive into that because I have done seller financing quite a bit with our company. What happens when someone does stop paying and you've sent them a notice for 30 days and they will not respond? And so I'm really asking for personal advice right now. Legal advice. Here you go. What are the things that I need to do as a seller when someone defaults on their payments?
First, you would look at the terms of the transaction. What does the document, the agreement itself say? If you have a land contract, there's going to be default provisions in there, and generally they're drafted. They're going to say, if I draft them for you as the seller, it's going to say, look, if you miss one payment, you're in default. You don't have to pursue the default at that time, but it's going to say what happens at that point in time. And usually the seller is going to be required to give them written notification. You're in default. If it's not cured by this date, I'm going to have to move to the next step. And that next step is to probably seek court intervention. Because you are dealing with private individuals, there are times when you can, and I usually encourage this, is there a way to work this out with the buyer that says, hey, look, you obviously are having some financial problems. You can't continue to pay me. Would you be willing to just deed your interest back over to me and basically do a walk away? A lot of times that will work out. When it doesn't, you are going to have to file a complaint to either cancel the contract or, depending on how much money has been paid in, actually go through a foreclosure process. So that takes a little bit of time. It kind of goes back to the benefit of getting a good, healthy down payment so that you have some cash there as a buffer during that period that you're not receiving, income from the property itself.
So I know that since she's given you some personal advice, she's working on her bill as we speak. So I think that's a good idea.
I'm working on the clock.
But Janet, so I'm a landlord, right? I have some rental properties and as things happen, like the furnace goes out, or there's always something going wrong. Is there a difference if I'm selling my property on a land contract, for example? Do I still have to go fix all of those things, and how does that work typically?
The land contract is a sale. That means that you've agreed on the purchase price, and your agreement is that if you pay me that purchase price, whether it's over time or lump sum at various times, you get the property. The property is yours. Otherwise, it's a lease. On a land contract, the buyer would take over all the traditional duties and obligations that go along with home ownership. That's paying taxes and insurance. That's maintaining the property. That's dealing with, the county, if the county comes and gives you, reasons that you need to do certain things to become in compliance with local ordinances and things like that. So that is the benefit, is that you're the homeowner. It's yours with all the good, the bad, and the ugly.
I want to dive into a couple different questions, just kind of talking about the disadvantages. So number one, what if the buyer files for bankruptcy? Can they still keep paying on the land contract, or does that get defaulted in their bankruptcy? So kind of maybe answer that one first.
Well, again, when you're the bank and you're the seller in that scenario, you have to deal with that the same way that a mortgage company would. And if your buyer files bankruptcy, you are automatically in a stay position where you cannot contact your buyer because you have turned into a creditor. You really are a creditor as the seller. But as a creditor in bankruptcy court, that is a federal law that says you immediately, and you'd get a written notice that states this, you immediately must cease and desist any contact with this individual until you're, told otherwise. So we have sellers that come to us, and I recommend that before you reach back out to that buyer and say, because you want to, it's the natural instinct to say, hey, what's this mean? You really just need to call an attorney that's going to be able to advise you what your abilities are at that point in time, what your remedies are, and what you can't do because you can be fined. And there's bankruptcy attorneys out there that will bring actions against creditors because it's very lucrative to do so. The law is very straightforward. People file bankruptcy to get relief from their debt, and so there's an automatic stay that goes into place, and you need to participate in that process. It's not all bad news. Most of the time in bankruptcy, people want to keep their homes. It's not all bad news. You just have to make sure that you're following the rules and you participate in the process.
And to go along with that, what are some precautions the seller can do before they sign off on selling this property on land contract? What are some things that they can do to protect themselves on, vetting the buyer? So
one thing that people I don't think understand as much is that once you sell your property under a land contract, and if you're doing it the correct way, you're going to make sure that that land contract is put of record. There's a statute called the Statute of Frauds in Indiana dealing with real estate, and the Statute of Frauds says that no transaction in real estate is enforceable against anyone else unless that is put of record. That's constructive notice to everybody else. Part of putting that of record then allows that property to be in the name of the buyer and then subject to that buyer's creditors. So when you, as a buyer, you want to engage in the process of checking those land records to make sure that the seller is legit, owns the property, are there any other liens? But as the seller, you also want to have the ability to run a title search that will give you a judgment search against that buyer. Things you can find out, and you may need to be specific in what you're requesting the search to reveal. Does this buyer have any judgments against them? If you come back with a litany of judgments, you're going to want to check those out and have a conversation. What's going on financially? Or can you see if this buyer has filed bankruptcy? If they filed bankruptcy within the past 8 years, they're not going to be able to file again. There's 8 years in between. That may be enough time for you to know they're not going to file bankruptcy. If they haven't, they could file, any day. Those are the kinds of things. I know that there's also vendors that will allow you to do an actual credit, check on those. And if you have the ability to do that, I think that as much due diligence as you can do, you need to do that.
Yeah, and as a landlord, people ask me that kind of question all the time, and we try to vet our tenants as much as we can. We try to check them and do some background, and there's only so much you can do. But I think if you try to make some efforts, then you're going to be better protected as you go forward. So we have a lot more questions for Janet. I know Brett and I have some things we want to get to. We've still got the hot seat left. I know Janet has a tip of the day coming up here in just a moment. So we will get to all of that information and more right after this break.
Central Indiana's premier real estate investors association, helping investors for 30 years. Whether you're a newbie or a seasoned professional, CIREIA has a wealth of information for you through meetings, classes, and networking. Check them out today at www.cirea.org.
And welcome back to Real Talk. My name is Ron Watson, President of the Board of Directors of CIREIA, and we're talking today with Janet Hocker, real estate attorney, owner of Hocker and Associates Law. Also joining me is Brett Snodgrass, local investor and coach. And I know Brett had a couple questions he wanted to ask you, Janet.
Yeah, Janet. So I know that we've talked about the advantages of seller financing. We've talked about the disadvantages of seller financing. And we were, just before the break, we were talking about precautions that we can have. And I know you own your own title company. So a lot of times when you talk about land contracts, you don't really think about going through a title company. You talked about, searching for judgments or searching for liens on the property, whether you're buying or selling. So talk about that a little bit. What are the advantages of selling a property on land contract or with seller financing going through a title company?
Sure. Most real estate attorneys are going to have a very close relationship with a title company because of all the services that they provide pertaining to real estate. And as I had mentioned earlier, to me, it was a no-brainer. I actually own my own agency. I want to have those tools readily available to me at the most cost-effective price for my customers. And the kinds of things that they do is they check the land entirely, the land history, the ownership of it, the tax history. Are the taxes current? Are they, is someone buying something that has a big tax bill on it and you're hoping that the seller's going to be able to pay that? Because if you don't pay your property taxes, eventually the county takes your land. So looking into all of those kinds of things, lawsuits that are pending is just a really necessary avenue of due diligence that either the seller or the buyer should do. And using a title agency is really a very cost-effective way to get your transaction done, especially if there's one that has a relationship with an attorney, because you're going to pay a one-time fee for the service. Really, they'll be able to take the transaction from beginning to closing, record it, make sure everything's done properly. And then if there are some legal issues that need to be dealt with, the attorney's going to be able to draft whatever additional documents may be needed to get the transaction closed. At our company, we like to say, if we can't close it, nobody can, because we think outside of the box. We try to get things done to make things happen instead of just hitting a brick wall and saying, sorry, we can't close, there's too many issues.
Yeah. No, that's good. I like that saying. Is that your tagline?
That's it.
That's good. And if somebody else can close it, you might want to really watch out because there might be something super hairy on it, right?
Right. Close it legitimately, legally, all that kind of stuff.
Awesome.
So hey, I was just curious. I mean, as I hear this information and learn more about the process and what's involved and what can go wrong or what I need to do to protect myself, I have this feeling that it's probably good to not necessarily go with your family attorney or somebody that's not necessarily focused on this particular area. Does that make sense?
It makes sense because the law is so vast and it's getting more vast every day. There's very few general practice attorneys anymore. I wouldn't go to a real estate attorney for a criminal issue or a criminal attorney for my divorce. And, you wouldn't hire an electrician to fix your roof. And there's just so much specific knowledge. And not only that, someone that is working in the real estate realm as an attorney every day is going to be able to provide you the service at a much more efficient and as well as cost-effective price. They're not reinventing the wheel every single time. You're just going to get a better service knowledge-wise as well as cost and time.
Since you brought up cost, can you talk a little bit about that? I mean, what can people expect to pay for a typical deal? I mean, I know there's probably not a typical deal, but can you give us some ideas of what that looks like?
Sure. As an attorney, if I'm actually hired by one of the parties to the transaction, I could not represent both sides to the transaction. I could represent the seller or I could represent the buyer. And if I do that in a transaction as an attorney, you're looking between probably $750 on the high end, double that. So that would just depend on how messy it is, how much negotiation I'm involved in, how many documents I need to prepare. I will tell you that the majority of the time, I don't need to represent one of the parties, and I can defer you to our title department to get the transaction through, and I would then just step in to kind of answer questions for both sides if necessary and get the documentation done. You're really talking about the same price because it's going to be based on the purchase price. And it could even be less than that. It could be like around $1,000.
Is there differences, appreciable differences between closing a deal that's seller finance versus a traditional closing? Is it going to take me longer to get through that process, or is it going to be about the same, or just it depends on all the variables?
We would consider that a cash transaction, even though it is seller financing. Really, any of those transactions, as long as the title is clear and there's not issues, that's going to be a quicker transaction than a lender financed through like a Chase Bank or something like that.
I want to dive into, because obviously you're an attorney, and there's a lot of laws. Things are changing all the time when it comes to real estate investing or the mortgage industry, seller financing, whatever have it. So is there anything out there that has came to light recently or within the last 5-10 years that you are concerned about with this method or anything like that?
I do get a lot of questions regarding Dodd-Frank, and that's just kind of a term that's out there. Goes along with the CFPB, the Consumer Finance Protection Bureau, which is was put in place in the last administration about protecting consumers in these transactions. And a lot of it came into the Dodd-Frank came into being because of the mortgage meltdown that happened in the early part of the 2009-10 era. And the reason it was put in place is because there was this belief. I don't think there's always some bad actors. I'm not saying that there weren't, but like most things, it's kind of an overcorrection. But Dodd-Frank was believed that seller finance deals were being had out there without the due diligence that a typical loan origination would do. Therefore, you had a much higher default. Well, we know in reality, most of the defaults occurred in the mortgage industry where loan originations were occurring. But that was designed to say that, look, we think these private seller finance transactions should be limited to the number that you can do. And if you're not, and if you're doing more than those, then you have to typically, you have to do what is typically considered loan originating. So that's what Dodd-Frank said, and there's lots of, I could provide any of your listeners a little flow chart that I have that really gives you an idea as to whether you fall under it or not. That being said, I haven't in the last 10 years had any investor be subject to enforcement under Dodd-Frank. What I usually tell them is just make sure that you are doing your due diligence. You are making sure that that buyer can afford the payment that you want from them. Look at their pay stubs, look at their tax returns, do the credit checks, do the types of things that you would, common sense, it would tell you to do to make sure that you have a good buyer there, so that if ever you are questioned as the seller, you can say, hey, here's what I did. And the fact that they defaulted later was for whatever, a job loss, a death, or anything like that.
And along with that, what about investors? If you're selling a property to investors, does any of this come up with that? Investor to investor
is completely exempt from any Dodd-Frank consideration.
And how is that determined? I mean, you just say, hey, I'm an investor. I mean, is there some qualification to make that determination?
Whether they're living in the property.
Okay.
Yeah, it's whether they're owner occupied in the property. One other area of law that you asked me, I'd like to just say, and this has been in existence in Indiana for a very long time, is that if that owner occupant under seller financing pays more than 20% into the equity of the property, so it can be by down payment or payments over a period of time, the law is typically going to require you foreclose as the seller, as opposed to just canceling the contract or deeding back or doing any of that. So I always say look at that 20% and see where you are with regard to that before you take any action against that buyer.
One quick before we go to break, I want to ask, does your law firm, real estate law firm, have any resources, education? I know documentation is huge, making sure your documents are correct. Do you guys have anything like that you can provide to anyone?
We do. I actually provide lunch and learn seminars on an as requested basis within my time frame. I've done it for several different offices of realtors as well as investors. just kind of can talk about whatever they want to talk about, or I can have a set agenda to kind of go over some things. I also have somebody within my title agency, Eric Downing, and he comes out and we'll talk to people specifically about insurance and what that actually means for you, why it's important, what maybe you can use, what you don't have to use, and those types of things, and what the forms mean when you get those back from the title agency. What am I looking at here? Why do I need to look at this? So any of those are provided. I also do a Tuesdays with the attorney through CIREIA for CIREIA members. My next one is May 22nd, and then I have one in August.
Where do you typically hold those, Janet? Or does it depend on?
Well, I think the last one we held at the Broadmoor Country Club, and sometimes depending on attendance, we can maybe do them in my office building. I have a conference room for general use.
Gotcha. Well, thank you, Janet. We have a little bit more information that we want to get to, including the hot seat. Yeah, Brett's shaking his head. He can't wait. He's very excited about that. And the tip of the week, too. We'll get to both of those things when we get back right after this break.
Real Talk, brought to you by CIREIA, Central Indiana's premier real estate investors association, helping investors for 30 years. Whether you're a newbie or a seasoned professional, CIREIA has a wealth of information for you through meetings, classes, and networking. Check them out today at www.cireia.org.
And welcome back to Real Talk. My name is Ron Watson, president of the board of directors of CIREIA. And today we're speaking with Janet Hocker, real estate attorney, owner of Hocker and Associates Law. Also joining me is Brett Snodgrass, local investor and coach, and the biggest fan we have of the hot seat. And it's now time for the hot seat.
Amen.
So,
I'm
Brett,
super excited.
What do you got for Janet?
Well, the first question is, I just want to hear one of maybe a crazy story that you might have that has gone right or wrong. And do you have any crazy stories?
Well, unfortunately, as an attorney, we get a lot of problems because usually they come to us, at the point of desperation. I get that. You don't like to talk to attorneys unless you really have to. And I think that probably one of the craziest things is someone that sells a house that they don't own. And they've sold it multiple times. You know, we've had people that have left the closing. And I mean, I think sometimes they feel like the real estate attorney and the title company have intimate knowledge about the building and the structure. And that is one thing that we never have intimate knowledge of. We don't go look at the property at all. Everything we do is based on records and written documentation. So the burden is on the parties to make sure that that property is there and there's nobody living in it. So we've had people that have left the closing to go to the house, and there are people, other people moving in.
Wow.
So, and that's
a little bit awkward when you pull up with your moving van and there's
we
people
own it.
in your
No,
house.
we do.
There was a person going around Indianapolis, and the Attorney General was very well aware of it. And it was when there was a lot of like foreclosure properties that were just out of control, lots of vacant properties with lock boxes on them. And this person was taking, the lockbox off, taking possession of the property very temporarily, putting a for sale sign in the yard, taking a $3,000 deposit, signing bogus, paperwork. And unfortunately, it was mainly against the minority community who just really wanted to get into a home. She did this multiple times at $3,000 a hit. And none of those properties were owned by her or any of those people. They all lost their money at that point in time.
Wow.
So they did catch her, thankfully, but we had a couple of those transactions that we were aware of.
Yeah, being in real estate investing, you always have crazy stories, and I was mentioning the story. The very first house that I ever bought was with seller financing, and I didn't know much about real estate, didn't know anything about seller financing. And I think Janet even mentioned about getting the land contract recorded, which I didn't even know that was a thing. We didn't go through a title company. And one other thing was that I never looked at the seller because he had a mortgage on the property that he was actually paying his mortgage. So now and he didn't pay his mortgage, so he foreclosed and I lost all my money and tried to go after him, and we got a little bit of it back, but not much. But if you are buying a property with seller financing and the seller has a mortgage, make sure that your balance is at least less than their mortgage balance, and make sure they're continuing to pay their mortgage. That's a tip. That's Brett's tip.
That's your tip of the week. We haven't got to Janet's yet.
Right.
That's fantastic. 2 tips of the week today. So, Janet, I did want to ask you, though, about that side of the coin. If I'm a buyer and, do you ever see that where the seller has problems, financially, whatever, and then all of a sudden, what's my recourse?
Well, yes, unfortunately, we do see that, and Brett's situation is probably one of the most common. I'm not saying it happens a lot, but if there are problems, it's going to be that a seller is not using the money that you're giving them as the buyer to pay their own mortgage. They get behind, and all of a sudden, as the buyer, you have a sheriff putting a notice on your door that your house is going to be foreclosed. There's lots of different things that you can do. Obviously, you have a contract with the seller, regardless of his agreement with his lender, and you can sue to enforce that contract. Sometimes you can, depending on where you are, you can refinance it before and pay off his lender and get him out of the equation, he or she out of the equation completely. The main thing, again, is get that consultation as soon as you can with an attorney to at least give you some avenues that you can pursue, because each case is going to be different. The main thing is, if you know up front that they have a mortgage, I like to put in there that you're going to make the actual mortgage payment, or
that's a good idea.
Or have a password to log into their account once a month and make sure they're paying it. So
that's a good idea. I would definitely ditto on that. So I want to put Hocker and Associates and you personally on the hot seat again, which we already on there. But so when you talk about attorneys and you talk about communication, attorneys and communication don't mix, because usually they don't communicate at all. You email them a few times and you don't get anything. So how are you and your law firm different, and how do you communicate with all of your clients?
That's the biggest complaint of attorneys. All attorneys know that in all areas. Even attorneys calling other attorneys, they don't call us back. It is a problem, and I have actually instructed the attorneys in my firm to put on their voicemail, and admittedly I have it on mine, is that they don't say leave a voicemail if you're truly not going to call back. I mean, if you're not going to call back, you shouldn't have voicemail. So the main way that we communicate with our clients is via email. And I know that there are some, clients of ours that don't use email on a regular basis. I have my cell phone number actually on my business card on the website. I understand that real estate, time is of the essence. It moves quickly. I feel that I am as responsive as an attorney actually can be, a little bit more so. But that is the best way to communicate with me, is through my cell phone or actually through my email, through my website, because I do monitor those on a regular basis. You don't have to go through my receptionist or the switchboard or anything like that. It makes it a little bit easier.
So how many of these deals have you done, Janet, and how many do you do on a monthly basis?
Well, my operations manager was just telling me that over the course of my time, we've processed over 25 billion in real estate transactions. Wow. On an average basis, I oversee about 200 transactions per month, and I have a heart for investors, so I have actually worked very hard to market and have a niche base of investor clients. So, probably 10% of that is going to be investors, which is all kinds of transactions, many of which are seller financed.
Yeah, and obviously I've used Hocker & Associates, and I just want to put a plug out for them. I've used them for many years now, and I've never heard anyone say bad things about your firm and your title company.
Thank you.
And people that do go somewhere else typically can come back because they know that you guys are rock solid, and it's just been a blessing. So.
Well, Janet, I wanted to make sure that you had an opportunity you talked about your cell phone, but can you share how people can reach you and what the best way to connect with you would be?
Absolutely. HockerLawFirm.com, pretty basic. We're on the web on that firm. There's going to be a picture of me. You can click on it. You can get to me that way. You also see my cell phone number on there. Janet.Hocker@HockerLaw.com. It's Janet with the period, Hocker@HockerLaw.com.
Okay, thank you, Janet. You survived the hot seat. I know Brett was really trying to give you the business there, but that's all right. Do you have a tip of the week that you can share with listeners?
I do, and I go back to what everybody knows. the call before you dig. I always say search before you buy or sell. And that just means do a title search. Search the land records, do a search of your seller, do a search of your buyer. And one of the questions that I get on a regular basis is, how can I make sure that I have no risk in this transaction? And my answer is, you can't. But you can manage your risk by doing your due diligence.
That's good.
That's really good advice. Yeah. And I just wanted to thank Janet for joining us this afternoon, and also Brett for being part of the panel as well. Please join us April 5th at our next main meeting, when we will have a landlord panel. Also, please put on your calendar to attend Janet's Tuesday with the Attorney session at 6 p.m. on May 22nd, where she will explain how to buy properties legally and safely at tax sales, estate sales, surplus sales, and other offerings. Find out more about Janet's session and our group at www.cireia.org. Once again, thank you, Janet, for joining us. Thank you, Brett, and thank you for listening.
Thanks, Ron.
You've been listening to Real Talk, brought to you by CIREIA, Central Indiana's premier real estate investors association. Listen to hear more every Sunday at noon on Freedom 95.